People accused of crimes and taken to custody are not only presumed innocent until proven guilty in a legitimate court, but they also have the right to bail. Much of that is contained in a book by Leslie Manu, a lawyer from the State Solicitor's Office. Bradley Gregory reports.
It's a constitutional right for every accused person to apply for bail. People and lawyers representing their clients have been going to the courts to apply. However, issuance of bail itself has been a difficult one. A senior member of the High Courts in Papua New Guinea, Acting Chief Justice Segib Salika, while speaking at a book launch in Port Moresby last week, says,
"We are divided on the aspects of bail, the judiciary. One judge will say one thing and another judge will say another thing. This is bail after being charged, bail at the district court, bail at the national court, bail after you've been convicted, bail after you file an appeal, and then bail while in the Supreme Court. That where cases are of a less serious nature, then I will grant bail. Where they're of very serious nature, then I won't grant bail. Yes, and I will usually use that the interest of justice. That little bit there at the end of that provision, in the interest of justice. Now I'm not granting you bail."
The book, titled The Law and Principles of Bail in PNG, is written by Leslie Mamu, who is a lawyer with the State Solicitor's Office.
Being an interesting area that falls within my area of practice, my expertise, that explains why I was interested in writing on the area of bail.
Also speaking at the launch was Secretary for the Law Reform Commission, Dr. Eric Kua, who is an author himself. He spoke of the need for more law books to be written by Papua New Guineans, more so the contribution of text by Papua New Guineans to Melanesian jurisprudence.
Why are we using foreign text to develop our law? They are, as we all know, they're persuasive. But we need to write the law that we have. And in the last 40 years, I've been thinking, we should now be able to quote textbooks by Papua New Guinean lawyers instead of still referring to personal evidence.
Leslie does a lot of bail work as part of his normal work. And in so doing, he accumulates the law as it relates to bail application. And he has reduced it into a readable book, which should be useful for many of us.
The book launched by Leslie Mamu will now contribute to the wealth of knowledge in legal studies, general readership, and understanding of the bail process in PNG. After all, the judiciary is one arm of government.
I've seen that law is a scavenger. It can feed on foreign ideas, and it can also feed on the discarded odds or hands that are produced as a result of our lawyers' laxity.
However, the judiciary has had its own challenges. Various comments made on the courts and their processes suggest the country maintains its vibrant constitution. Approaches have really changed, with it the challenges. Some of these challenges highlighted were methods used by people aimed at prolonging the court process. The country's Task Force Sweep Chairman Sam Coim believes the procedural proceedings, though as equal as substantive matters, have really taken too much of the court's time.
We lawyers, in our ingenuity to bring in our clients' cases before courts, sometimes we embark on situations where we replete the court system of processes with all manner of unnecessary applications. And sometimes the local jurisprudence is dragged into a part where the law is not developing the substantive law, but we sometimes become very litigious society in concentrating a lot of judicial time on probably the procedural law.
He adds many times lawyers become lazy and present only unprocessed facts to the courts, which shouldn't be.
Us who can help the clients by processing those raw facts into legal solutions. If there's something that we can help our clients to solve it outside of the court, we do that.
Dr. Kua acknowledged the comments. He says the judiciary has seen many of these and is now become proactive in its approach to the cases.
And I'm beginning to, when I've been reading these cases, on finding these words and phrases that I'm trying to then interpret from the judges, that judges in our courts today are becoming more proactive. They're telling you, so what is the law on this? What did we say 2 years ago? So really you can't trick the judges, you can't trick the courts. There's enough evidence.
We from the bench know which lawyers we can trust and or that you can feel comforted that I'm not going to be given another day of useless arguments or thoughtless submissions that lawyers, some lawyers do make thoughtless submissions.
Bradley Gregory reporting there. This is PNG Tonight. Stay with us. We'll be back at the other end of this break.